titled Immigration's Institutional Values. I should briefly just say something about the title. This conference has been an absolute joy to organize. One of the things that I found challenging was not putting together panels, but then coming up with titles to make some sense of the panels. And going back to my days, a member of the program committee on Law Society, and many of you that have been a part of that, you know that there are inevitably dozens of papers that don't quite hang together, and it's your job to put together a sensible panel. And I felt, I had all these great papers with Tino and Deeps and Mike's, and I think late one night this was the product of what I was struck by in terms of the combinations and the linkages between the three. So very briefly, let me just explain more about what I mean. I think the title of the panel might be more accurate as Immigration's Values and Institutional Constraints. I think that's something that is captured in all three of these projects, is this notion that there are certain values that run throughout immigration law and law generally. And what becomes really interesting is when those interact with the constraints imposed by law and whether and to what extent the product maps onto our initial ideas of what ought to be the case. So let me just briefly introduce our panelists, and then I'm going to hand the microphones over to them. And as been the practice, I'll give them about 15-20 minutes. I'll probably pose a question or two, and then leave the remainder of the time for discussion with the entire audience. So Tino Cuellar has been a member of Stanford Law School since 2001. He served in the Obama and Clinton administrations and testified for Lawmakers, and has a really long record of involvement in public service generally. His research and teaching has focused primarily on administrative law, executive power, and how organizations implement a variety of mandates. He graduated from Calexico High School in Southern California and has degrees from Harvard, Yale, Stanford, and clerked for then Chief Judge Mary Schroeder. Deep Gulas Lakaram, is that okay? That's twice now.
Yeah, it's good. It's okay.
Deep, well, thank you, Deep. Deep, my good friend Deep, is here from Santa Clara, and he researches and teaches in the areas of con law and immigration. He writes on a number of topics. Most interesting to me on the intersection of non-citizens and gun rights. And he shared with me a number of the interesting speaking engagements that research expertise has opened up for him. Prior to being in Santa Clara, he was at NYU as an acting assistant professor. He's practiced with Melvin Myers, Susan Godfrey, and clerked for the Fifth Circuit. And then to my immediate right is Mike Wishney. He's a clinical professor at Yale. Prior to that, he was at NYU. He writes and teaches areas of primary immigration, labor, and employment law, and is clerk for both the Third Circuit and the Supreme Court. So we're going to start off with Tino, the political economies of immigration.
Thank you. So I'm going to try to put this on, but before we get into the jokes of how many law professors it takes to... Does it work? Is this on?
Is the on button?
We fixed immigration now. So I had this joke that I wanted to tell about how the room smelled like new car, but without risking an intellectual property lawsuit, I'm just going to leave that aside. I do want to say, just as a little bit of context, that last night I was trying to fall asleep, and to my shock, around 11:45 p.m., a big party began on the roof of the hotel where I was staying. And further to my surprise, most of the music was from the 1980s and the early 1990s. So that will explain, some incoherence today perhaps, but also I was thinking about how to present some of the information that I want to share with you in a short amount of time. And it struck me that one good way to do it might be to start by talking about the different contexts for immigration law in the 80s and early 90s relative to today. So I'm going to get there, but I first want to also say that the whole conversation has been enormously helpful, generative, interesting. I do think that precisely the right way to frame this discussion is to have us talk about puzzles. We've been talking about different puzzles, and the way I want to approach this topic is to say that there are puzzles in individual areas of immigration doctrine, I certainly find it really puzzling to think through how to harmonize about 200 years worth of constitutional law that has a bearing on how we treat aliens. I find it puzzling to ask how we square the circle with respect to extraterritorial jurisdiction and the Constitution. But there is also a larger puzzle lurking in the background that I would argue animating a great many different doctrinal areas in immigration, and that's the puzzle of what do we make of a system that has been enormously persistent over the last 30 or so years, and yet almost everyone in the country is rather intensely dissatisfied with it. And a related puzzle, which is the one I'll pick up today, is what can we learn in trying to understand that and disentangling all that from looking at the institutional relationships between different actors and different parties, different interest groups, different institutions in immigration. So I want to start simply by zeroing in on one particular case to illustrate how the bigger dilemmas in immigration law are sometimes reflected in individual cases. I'm going to start by going to this picture right here. This is a restaurant, Sizzler. I've eaten there myself, and it's in Phoenix, Arizona. And in a Sizzler like this, the facts began for a case that is well known to all of you who teach immigration, and many of you who practice immigration, which is the Collins Foods case. And in that case, as you may recall, the Ninth Circuit basically addressed the question of when an employer has constructive knowledge that the employer is hiring an undocumented worker. I simply want to point out that everybody, probably even Collins Foods, was dissatisfied with the decision there. On the one hand, the Ninth Circuit said, well, despite the fact that the employer failed to inspect the back of the purported Social Security card, which was on its face essentially obviously a forgery, despite the fact that the employer had essentially offered the job to somebody who's in California, being in Phoenix, without inspecting documents, we're still going to say that the employer did not have constructive knowledge that this individual was an undocumented worker. Now, it probably left Collins Foods dissatisfied because it wasn't necessarily clear what did count as constructive knowledge. The ambiguity persisted. It probably left people who believe that the problem with employer sanctions is that they're existing at all dissatisfied, because of course the court didn't do anything really to disturb that. It probably left people dissatisfied who feel like the problem is that employer sanctions are not being enforced strictly enough. And my point here is that Collins Foods came barely 5 years after IRCA created a really unprecedented employer sanctions regime. We've heard some about this, that generated a variety of dilemmas involving employers, workers, and government agencies. 20 years later, much of that legal regime is still in place, even as a variety of important background factors about our society and our immigration system have changed. And so the puzzles I'm going to take up, given those changes, are why does immigration law stick? And more directly, how do the institutional actors affecting immigration law relate to each other? And I'm pretty sure that I have some pieces of the puzzle. I know I don't have them all. But I would submit to you that these pieces of the puzzle should be part of the conversation. And from my perspective, my contribution is mostly in the descriptive vein. I'm not really getting into the issue of judging the particular features as much as I want to tell a story about how the particular features we have tried to incorporate into our immigration law are in tension with each other, create difficulties and contradictions that then reverberate in the public sphere. So, the main points I want to make in relation to that puzzle is, number one, that whatever else immigration is, it's a system for defining community, but it is also a complex regulatory system. It's a mechanism for trying to make real commitments that society has. Second, that the statutory structure of immigration law is pretty critical in understanding a whole variety of doctrinal disputes, including questions about employer sanctions, but many others too. And then finally, and most importantly, that immigration is affected by what I call multiple political economies. Different dynamics that exist at the stage of the production of lawmaking, so what went into IRCA, for example, in establishing what is essentially this current chapter in our immigration history. Second, a political economy around how laws are implemented. What do agencies do? What incentives do they have? Why do they act the way they do? So the question that the last panel was touching on involving how might the Labor Department be different from the Homeland Security Department? Why do we have so many agencies dealing with immigration? What does it do to put the enforcement responsibility in DHS, but to make DOJ responsible for immigration adjudication or for defending what the federal government does in court? What consequences arise? And then last, but certainly not least, there is a political economy around how the public responds to this. And let's understand, the public is not just one entity. But there are many, many, many millions of Americans who have become part of the immigration conversation. And one of the questions I want to take up is how do they then get affected by what they see? What frustration do they feel and how do they take that out, irrespective of whether we think the original regime was the right one or not? So it's helpful to frame the conversation, going back to what I heard last night, by thinking about some of the differences in context between the 1980s and the last decade. Many of those differences are quite staggering and very familiar to this audience. IRCA, the signature piece of immigration legislation in the 1980s, for all its faults, you could say, had multiple goals. It included legalizing the undocumented as well as creating an unprecedented new employer sanctions regime and beginning a very long ramp up in border security. The percentage of the total population consisting of undocumented individuals was far lower. This is what it looks like. It's a very familiar trend for many of you. And so we've gone from a situation where we had about 1.7 million undocumented to a situation where we have about 11.1 million. Now let's look at what happens if you look at how the media covers this issue. This is a graph that we came up with that reflects news coverage in the 4 major national newspapers in the United States, the Wall Street Journal, the Washington Post, the New York Times, and fourth I think is USA Today. And as you will see, there is a striking trend in terms of far greater news coverage. And the front page, this is American newspapers. This is a proxy for what you see in other media sources, which we've also looked at. What you'll also find interesting is what you see here in the purple line, but I can dramatize even more in this graph right here. That's the proportion of those immigration stories that deal with the border, primarily. So we are having a conversation about immigration that is turning into a conversation about the border. That is a trend that has been reflected in our policy choices. This is also a familiar graph for many people in the audience, and it shows the absolutely striking increase in border enforcement resources. There's a long conversation we can have, and some of the paper covers it, about what the legacy of this is, what impacts it has. But for my purposes, I just want to underscore that this is a trend that has complex effects. Some of those effects that Massey and Wayne Cornelius have written about involving changes in circular migration patterns. It has an effect on the border communities themselves. It has an effect on where enforcement resources are going. For my purposes, it's also important to note that it has an effect on how the Justice Department operates. If you look at the Justice Department's budget, by the way, this is just a small footnote, but something you'll find interesting. It is a budget that has grown fairly consistently over the last 10 years. But everything the Justice Department does has been squeezed by an increase in budgets for national security functions and for detention. Everything else that is in the middle, everything ranging from civil division representation of the U.S. government in court with respect to the validity of federal programs, environment and natural resources, civil rights, has been squeezed. And within that piece that's been squeezed, what is now, I believe, the biggest section within the civil division is the immigration litigation section. And that's partly related to this in as much as you have to understand that these resources generate people who get detained, which then generate litigation and claims and issues that have to be adjudicated. I here want to just point your attention to what we could say about how Congress is changing its focus. What I have here is the percentage of bills covered in the Congressional Quarterly Almanac, which is the main source for information on bills introduced in Congress, and the percentage of congressional hearings having to do with immigration. So you can see here also a changing picture, a situation where back when big immigration statutes that had a variety of purposes, like IRCA, like the 1965 immigration law, were passed, a somewhat different context arose. And now Congress is actually more engaged and more interested in tons of different kinds of immigration litigation, but what you mostly see passing are changes involving border enforcement and security and the criminal immigration link, and I'll have more to say about that in a second. All right, so all these facts, I would argue, form part of a dispiriting narrative about modern immigration law. My main argument is then to suggest that these different changes relate to each other in a number of different ways. I would argue, in particular, if you look at the core challenges and problems and contradictions in a statute that passed, that essentially passed along with a commitment that was made to the public of the American state, which was, we have a solution to our immigration problems. We're going to ramp up security in the border, we're going to implement these employer sanctions, we're going to legalize, we're going to reset the system, and all will be fine. And we know that the contradictions in the law were problematic. I'll talk a little bit more about that. But then you have to run through the fact that we don't have a perfect system for enforcing even what would have been a more harmonized and carefully designed statute. You have agencies that have quite different incentives and argue with each other, slow each other down, and don't work together particularly well. And then the last piece of this is a dynamic that I refer to in the paper as polarizing implementation. A dynamic that takes agency failure, creates incentives for politicians to be more angry about immigration, in part response to what the public believes, gets lawmakers to pass laws that actually increase the burdens on the agencies, and then creates a situation where the public and politicians watch the agencies fail and want to pass even more legislation, making missions even more complicated for agencies. Briefly, statutory dysfunction. In the paper, I talk more about this in detail. I suggest that what we're really dealing with is a scheme that was in some sense not built to succeed. Maybe saying built to fail goes a little bit too far, but not by much. It established a framework rendering unlawful vast tracts of labor market activity previously unregulated directly, and coupled that framework with what I would describe as a rickety, easy-to-evade system drastically limiting enforcement. In the paper, I contrast this to regulatory schemes that actually work quite differently. Let's take, for example, how the Federal Aviation Administration monitors safety in airlines. Or you could say, how does the CDC know when a big spike in food safety problems arises in a particular state? We know how to build different statutory schemes, but Congress chose not to do them. Organizational fragmentation. The paper explores some of the problems that arise in this area, including squabbling between ICE and CBP and CIS, all within DHS, the presence of EOIR and various criminal and civil litigation functions in DOJ, which basically involves consequences that one agency doesn't own, but that are resulting in impacts on the other agency. Over the last 5 to 6 years, DHS has accelerated the trend of building up border enforcement resources without much concern for the downstream effects. But more generally, I would argue that creation of DHS and the consequent three-way split in immigration-related functions within DHS, as well as the fragmentation across cabinet agencies, creates agency priority challenges and transaction costs, if you want to put it in those terms, for whenever it comes time to changing policy. This is a graph that tries to grapple with the question of how much control does a president actually have over immigration enforcement? So here in the paper, you'll know that I part company a little bit with Rodriguez and Cox, who argue really the president has a lot of control over immigration. I think a more nuanced perspective would be to say we've got to understand the full range of pressures on the executive branch. It's a set of pressures that includes resistance from agencies, it includes resistance from Congress, it includes frustration from parts of the American public that might respond adversely to changes. Even then, you do see some really interesting trends here, but they're not necessarily the ones that are obvious. The normal picture that one puts up involving removals is just the raw numbers. I think that's an important and dramatic picture. But here I've looked at the percent change in removals averaged out over presidential terms. And what you see really is that what set in motion a set of bureaucratic and agency activities that put us on a particular trajectory was a set of choices made really in the second term of the Clinton administration. And in the paper I talk more about why that is, how that has an impact, but it just suggests that there is a real question we have to struggle with respect to how much presidential administrations have an ability to completely ramp down and change what gets put in motion in a different administration. Right here I'm just showing you what is happening with respect to public reactions. On the right, I've got a graph that is really about trust in the federal government writ large. But I have similar data with respect to trust in the federal government's ability to implement immigration law. You see a big dramatic drop, just as at the same time you see a big increase in the public's sense that immigration is actually big and important issue. And all of that, for me, helps suggest, at least, that there's a pattern that I call polarizing implementation, and just briefly to explain it, it involves growing public concern and enforcement problems that were, in many respects, as I argue in the paper and as we've discussed here, built into the statute, but that get worse over time, that encourage lawmakers to seek further changes, and many of those changes, I think, are best understood as actually imposing new burdens on agencies that are already not particularly able to do the job very well. But what about Congress actually increasing resources? Well, this is a graph that I find interesting and tells the story of what's happened to interior enforcement resources in the years before the INS was put into DHS and broken up. After that, it's a little more difficult to figure out exactly how to do the accounts because some of the money is in different categories, but I'm looking into that. And all that I'm trying to show here is that if you actually look at interior enforcement resources relative to the size of the undocumented population, you actually see a pretty stark decline in those resources, which suggests that something is off with respect to the political rhetoric relative to what is actually happening. I'm not suggesting that problems in immigration law can be fixed by changing the direction of the graph. What I am suggesting is that it tells you something about the dynamics that are affecting agencies and their enforcement choices, why they go for certain kinds of enforcement rather than other kinds. And then those three spots right there are just a few examples of instances where whatever else the law was doing, at least one aspect of the law, was to get immigration enforcement agencies more involved in something that they were not doing before. In particular, including the removal of large numbers of lawful permanent residents. And that doesn't even show up in terms of the graph, but it just gives you a sense of how resource constrained these agencies were. Let me quickly recap and highlight a few implications. I've tried to suggest that to understand immigration law, we have to understand different kinds of political economies, some involving implementation, some involving lawmaking, some involving public reactions. I've suggested that since the 1980s, we've been in this polarizing implementation cycle where border enforcement gets ratcheted up because it's easier to implement with less interest group resistance. And there really has been no fundamental change in the architecture of interior enforcement, despite the frustration and the anger that much of the public feels. In the paper, I talk about how there are two implications that I think are interesting from a more scholarly perspective. One has to do with the literature and political science on policy feedback. This is the idea that when laws pass, it's not necessarily clear whether they're going to survive. And that depends a lot on the constituencies that are created that become interested in supporting those laws. I suggest that what's happened with the changes in immigration law is basically negative policy feedback. It's a cycle that delegitimizes the law and increasingly makes it a source of frustration for almost everybody who's touched by that. And then second and last, I argue that there are real questions about the relationship of even powerful nation states to trends that are difficult to control. Here, I'm going to just refer a little bit to the point that the moderator for yesterday's panel made at the end about how challenging it is when a state tries to regulate something that's very difficult to regulate. I do think that suggests that it's important to think hard about not only what are the limits of a state's capacity to regulate powerful things that are happening in the world. I do think there are many things that can happen with immigration law that have a big effect. But then the other issue is, how is that explained to the American public, and how much is the public able to understand those limitations and able to support changes that have a variety of trade-offs that sometimes people are not willing to face. Thank you.
All right. Well, thank you all, and thank you, Stephen, for the invitation. It's true. I like to write mostly about guns. I don't know. Oh no. It's kind of sad. Okay. How many lawyers does it?
Let me give it a shot.
Okay.
Sorry.
I'm wholly relying on my pictures.
The computer got really frustrated with what I was saying. So there you go. And now, how do we just get the slideshow? That worked.
Oh, is
Time out.
Time out.
That's what I tell my kids.
No, I do this in front of the students.
Now we're-
Come up to me right now.
Okay, we're good. We're totally good.
Nice
All right.
job.
So I was saying is, I do like guns, and I don't have any myself. I like writing about them. And so right now I'm well out of my depth, but I took Stephen's invitation to talk about puzzles as really his suggestion that I should stop talking about guns and think about something else. So here's my attempt to think about something else. I pitched this idea, by the way, I only had 3 pages that I uploaded that reflects the state of my thinking on this at this time. The 3-page thing says there's a part 1, 2, 3, and 4. But that's really just a cheat so that Stephen wouldn't think that I did nothing else on it. But hopefully after today I'll be able to fill in the rest of it. The idea here is to think about one puzzle, and here we want to think about the border wall or muscular or fortified border policy. I think this project may fit into what Tino was just talking about. Perhaps if we think about Tino as taking the 30,000-foot level view of what's happening, perhaps this is a granular data point in what Tino is talking about. Generally, when I think about the border and the idea to build a border fence, I think there's a lot to dismiss, right? That it's not really a serious policy, it's not really worth thinking about. In fact, that's actually how I felt about it until Stephen forced me to think about a puzzle. And then I thought maybe there's another story to be told here, right? Something a little bit more nuanced about the decision to create border walls and fortified physical borders. And then perhaps a nuanced story about how that wall, once created, in fact impacts the way we think about immigration, the way we think about undocumented immigration, the way we think about enforcement of immigration law. And so that's the project here in exploring this puzzle, to see if in fact there is a more complicated story to tell, and maybe at the end of the day we say no, there actually isn't, it's just kind of a dumb idea, and we should stop talking about it. But before we get there, this is the Secure Fences Act 2006, proposes to build significant border enhancements over a number of places in the southern border of the United States, roughly totaling about 700 miles in a roughly 2,000-mile border. It looks solid on this map, but if you actually take a look at how it ends up being built, it looks a lot more like this. That is non-contiguous stretches that total 700 miles across the southern border. If you take a look at DHS's own maps, right, they sort of take the high view of it and show you that it looks mostly constructed. It's hard to see on this map, but they have little pockets that are still under construction. This is a map that's current as of exactly 12 months ago, or I think, yeah, a little over 12 months ago, to showcase the progression on the border. And I think even according to this map, there would still be roughly 50 to 100 more miles of construction on the border fence left. The text that you see is the actual text of the Secure Fences Act, and so it defines operational control as the ability to eliminate and stop unlawful entry. There's a concern with terrorists and other contraband as well. The conventional, what I'll call the conventional critique, is to attempt to measure this purpose stated in the Secure Fences Act against the utility that the wall actually brings, or its effectiveness in accomplishing the stopping of people, unwanted crossings at the border, right? And so this is an example of what I'd say like the conventional critique, right? The idea of that the border is surmountable, right? It actually can't do what it intends to do here. The title of the YouTube clip, 2 girls undermine entire U.S. border strategy in under 18 seconds. And I suppose if we thought that the border policy was meant to stop people from climbing over a fence, then we might say it has been undermined in less than 18 seconds. The other critique is from the point of futility, right? The critique that even Governor Napolitano, or then Governor Napolitano, when she was governor of Arizona, said famously, I forgot the number, but if you build a 14-foot fence, I'll show you a 15-foot ladder, right? And so the critique of futility. And I think all of these are creditable critiques. The critique that you hear often in the literature, sociological literature, and economic literature is this, right? That even if we don't worry about the first two critiques. If we think about the purpose of building fences, it simply is, it costs way too much to do, right, monetarily, and it has significant human cost, right? That is, without deterrence or actual stoppage, it just creates more deaths. I think all of this is very useful, and by calling it the conventional debate, I don't mean to think of this as not useful critique. The only issue, though, is it doesn't appear to explain what's happening, right? The fact that border wall and thinking about border wall and the thinking of a fortified boundary has in fact accelerated rather than decelerated. And I don't think this is a problem necessarily of a failure of data. I think there's significant data on both of these points, the cost point and the death point. Nor do I think it's necessarily a problem of speaking loudly enough to the correct people. And so the project of this paper is to see, what other stories can we tell about the creation of a fence and why it gets created, and then once created, what are the factors that help keep it going, and then what can we say about the future of border policy and immigration policy generally if we can abstract from the existence and creation of a fence. So what I'm trying to do is broadly tell this story, and I think the easiest part of this story is a story about policymakers, right? Our federal lawmakers, and I think this is a point that Tino alluded to, and several people have made this point, right? There's a lot of political currency in saying that you're going to be tough on immigration, right? And that's not news to anybody, and that you can gain a lot of political points by doing that. So it's one factor. The second factor is that I'm going to argue is the creation of a fairly robust statutory scheme that attaches significant legal consequence to border crossings or to unlawful entries or entries without inspection. Now, the first story, the story about lawmakers, right? It's a story that everyone's heard. What's interesting, and perhaps it's just confirmation of the point, is if you look at the voting on the Secure Fences Act, right? Really interesting. I mean, it passes with overwhelming majorities in both the House and the Senate. I think the Senate vote was something like 80-19 with one non-vote, and the House vote, similar proportion of people. I think even more votes in favor of the border fence. Interesting thing about the fence of the border, at the southern border, it only runs through 4 states, California, Arizona, New Mexico, Texas. Those are the states from which the most number of nay votes on the Secure Fences Act come. There were 17 states in which all representatives voted in favor of the Secure Fences Act. 13 of those 17 also had both senators also voting on the Secure Fences Act. And this, again, just confirmation of the point. It's interesting when you look at those states, like none of those states actually have an international or maritime border. I think if you look also just at their immigrant population and projected or estimated unauthorized population, they all fall somewhere between 30 and 50 in terms of overall United States rent, right? So it's interesting, I think, just to think about those numbers and where this idea, I guess, again, confirmation of this idea. There's a lot of political points to be scored in this arena. California, by the way, had a majority of its representatives vote against the creation of the passage of the Secure Fences Act. So I'm suggesting that, obviously there's good reason why you'd have fences, or at least a muscular border policy based on the political points that one can score. But that doesn't necessarily mean that it has to result in a fence, right? It could just mean all sorts of muscular border policy. And so the second part of the story that I think I want to tell, and hopefully we'll see if I can, is that once you create a robust statutory framework, a robust regulatory framework, and commit yourself to rigorous immigration, at least a rigorous immigration enforcement scheme in the background, you're virtually compelling the creation of an object-oriented outcome. And here, that object-oriented outcome is the creation of a wall. I think this is true, or what I want to argue this is true, and I want to get here by thinking about the work of political philosophers and psychologists, is that these powerful legal tools that we've created in the background to help to give legal sanction to unlawful entry are all invisible, Right? They do the real work of immigration law, but at the end of the day, it's hard to see unless you're watching, for example, images of a raid happening and those sorts of pictures. It's really hard to see, but offense is visible, right? It's tangible, it's physical, and in that way, because of its tangibility, I think it makes visible this invisible background border policy. So that's the one point I wanted to make. The second, though, is that once created, the fence has some palliative effects. And here I'm looking at expressive law theory for the idea that you don't really sometimes need law to function by actual deterrence, right? Sometimes law functions by what it expresses, what it symbolizes, and what it may mean. And so here, the argument that offense gets created not to deter, but because it has some ancillary effects. It has palliative effects on the citizenry, right? It creates senses of comfort. It fulfills the psychic need to think that the federal government, an omniscient protector, is actually doing something to in fact protect. I wonder how this would map up, the 2006 Secure Fences Act would map with Tino's data about sort of the public perceptions of immigration and when things need to be done. And there might be a story to be told there as well. In addition, there's, as I said, the fence has expressive effects on the public, but it also has expressive effects, I think, broadly for federalism-related structural power types of issues, and I'll try and explain what I mean by that in just a second. But with regards to the citizenry, I think one of the things that a fence does, and this is, again, partly political science and political philosophy literature, is that it helps create this fantasy of what we're protecting inside as well. And it does so through proclamation, right? Without empirical fact, but it creates the perception, at least, I think obviously partly something that we can back up, but this idea that there is something fantastic and great behind this fence. And for those already inside, the perception that you live in a world that is exciting, it's the best, and this is where everyone wants to come, regardless of the empirical truth of the proposition. This is painted on the outside of the Israel-Palestine wall. This is the view from the Palestinian side. For those of you who are familiar, this is the work of Banksy, who some people would call a public artist, other people would call him a graffiti artist, others would just call a vandal. If you haven't seen the movie Exit Through the Gift Shop, I highly recommend it. That might be the most important thing I tell you up here. It's the creation of public art. So it protects some idea, this creating this fantasy that helps us disconnect from what other authors have called the traumatic reality. The traumatic reality being that migration can't really be stopped, or that this idea of protecting the good life that we have in America is going to constantly, it is going to suffer pressure from what we consider to be the basic life that's lived everywhere else. The effect that I want to argue that it has, other than this palliative effect of making us feel good, is actually the effect of creating or thinking about the foreign relationships with Mexico and Central American countries. It helps us think about this, it helps the citizenry think about this in ways that they can understand, right? Offense helps us domesticize the relationship between two countries. Here I'm arguing, essentially taking, not from Mendingwall, the point that good fences make good neighbors, but rather the fact that it helps define the relationship between neighbors. Right? It helps us understand foreign relations as we would understand residential relationships, and it helps import the norms of property law into immigration law, right? It makes the violations, trespasses, makes immigrants more culpable. It helps us take away the narrative of the migrant worker coming for work and displaces it with a violator, right? One who's willing to trespass into the United States. The palliative, or so the effect, I think, in the structural question is to help us understand in a visual manner that immigration is and can be only a federal responsibility. Why? Because the fence has to cross state lines, because the expense of the fence can only be borne by the federal government, because of the number of federal laws that have to be abrogated in order for a fence to be built, are all things that only the federal government can do. So it has possible effects that way as well. I think the more interesting story, the story that I'm interested in, is then once built, then what else can the fence do? Why does it sustain itself? Well, I'm going to argue it's a self-sustaining, self-invigorating phenomenon. And here I'm going to argue that the fence, once created, once there, regardless whether it actually deters, actually does two really interesting things. That first, because it imports culpability as a trespasser to the migrant, it justifies greater interior enforcement, or greater enforcement, right, the extended border controls because of the trespass. Second, it has this effect of actually being constitutive of the problem it purports to solve. Here, what I'm going to argue is taking from expressive law literature again, one example that Dan Kahan uses is that the creation of significant tax penalties often convinces people that there are a number of people, a great number of people actually avoiding taxes. And as an empirical matter, that need not be true. And in fact, he's shown through some empirical data that just the existence of the penalty makes it seem as if the problem is greater than it is. Here, so too, very simple story to tell, right? The existence of the fence substantiates the fear that there is, in fact, an alien invasion, the terrorist threat through the southern border is real. And the final thing I'll argue here is that, in fact, the creation of the fence spurs greater fence making. Right? Here, private actors, the Minutemen, because of the creation of the physical fence by the federal government, engaging in the act of creating a fence, which in then turn spurs government efforts to then fence in the areas also fenced by the Minutemen and private groups. The final thing I'll say is that in this area, there was most recently, if you saw, we've abandoned, DHS abandoned this creation of virtual technologies at the fence, but did not abandon creating more of the physical fence. And here, the critique that's often leveled is this is sort of odd, right? Why would we abandon these high-tech ways of surveilling the border, thermal imaging cameras, etc., for these extremely low-tech methods of building a fence and trying to stop people that way, if we assume the point is to actually stop people. And one of the critiques leveled against the fence is the critique that it's an anachronism, right? It takes us back to the time of moats and castles and that sort of thing. Why would we ever do that? It's sort of an easy way to mock the fence. And what I think I want to argue here is that that's exactly the point, right? That the idea is to connect the fence to times of antiquity. It is to conjure a time immemorial that precedes the idea of a politically constructed border or a legally constructed border. That is, a fence is something that is natural and normalized in the public imagination. The advantage of doing that, of course, is that once natural, the idea of attaching significant legal consequence to the fence it flows fairly easily, right? You don't have to justify why the border should be sanctioned in the first place. You only have to worry about perhaps the proportionality of sanctioning the transgression of that border. And in fact, this idea of conjuring the moat isn't just a faraway idea, right? There is, in fact, the story from 2008 of a city in Arizona that is actually thinking about creating a physical moat around the city to combat the idea of unwanted migration. So the final thing, and then I'll stop as my final slide, is to just ask, what does this mean and where is this going? To that I have no real answer. And I wonder, some people think about the creation of a fence as the ultimate act of a sovereign nation state. And I wonder if that means ultimate in the sense of it is the most powerful act of a sovereign nation state, or it's the ultimate in that it is the ultimate, that is, it's the last act of the nation state before the decline in the importance of the national border. And that's an open question. I think it's hard to answer. I think unless we take a look at historical, sort of developments of borders and the demise of borders. But I'll stop there with the fun.
Sesame Street imagery. Which of these three law professors doesn't teach in California? Thank you, Stephen and Brittany and Jennifer and everyone for having me here. The last time I was in this area south of LA, about a year and a half ago, I was here with a student to spend the day deposing a senior ICE official who had run a program that led to the arrest of hundreds of Arab and Muslim men on the eve of the 2004 election. It was an interesting deposition, but I'm much happier to spend the afternoon with you guys. The puzzle, to use the framework that is not on the paper, that drew me into thinking a little bit about proportionality was the rash of state and local conflicts over immigration enforcement, from SB 1070 in Hazleton at one side to my own town of New Haven, Connecticut, where the police are forbidden from doing civil immigration enforcement, and there's an optional municipal identification card available to all city residents through government-issued ID for all residents regardless of immigration status. And of course, between New Haven and Arizona, and many communities across the country have been in battles these last few years. And I don't think it's any secret to say that the real struggle is not about the precise allocation of state-federal relations and federal power. It's really a substantive dispute about the content of our immigration policy. And the way that state and local communities can have that dispute is really only about enforcement, whether to help enforce the laws we have or to perhaps reduce enforcement of the laws we have. Because, of course, the state and local governments cannot themselves create new grounds for inadmissibility or new forms of immigration relief. So they fight about whether to enforce the laws we have. And really the debate in some ways I think can be thought of is whether the laws we have are proportional, whether the sanction of removal is proportional to the offense that prompts one to become subject to removal, whether one is in legal status and commits some act, criminal offense or some others that could lead to removal, or whether one is not in lawful status and on that basis is subject to removal. While there may be those who say we should deport everybody, or those who say we should absolutely have open borders, that's actually hardly any of the debate. And I think really what the public debate is about in part is, of the people currently subject to removal under the laws we have, should they be? Or should all of them be? And if so, who? And if not some, then who not? Who should it be? Others have said this is new territory. This is definitely new territory for me. I was alarmed when Hiroshi said, I'm just getting into this project. I've only been thinking about it for 5 years. This has been about 6 months for me, but that's sort of squeezed in among depositions and court appearances and stuff. I think Hiroshi reads more in a week than I read in 6 months. So this is truly sort of skimming the surface. But here's the idea, and I think it's, in some ways it's a small idea, in some ways it's a potentially powerful and important idea, both for some of the discussions we're having today, immigration and conceptual, and also quite pragmatically for the immigration lawyers in the room, and some of you I know are here. And it's simply this. Proportionality is an ancient concept. It goes back in Anglo-American law, at least to Magna Carta, and it finds manifestation across legal disciplines. It's reflected in parts of the Constitution, in parts of our case law, the basic notion that the punishment should fit the crime, that the sanction should not be excessive in relation to the offense. And the notion is developed in 2 particular areas of case law. This is the sort of small observation that maybe opens into something more significant. On the criminal law side, and there are those in this room who are much more familiar with this than me, under the 8th Amendment, cruel and unusual punishment, there's a century of cases in which someone has challenged their criminal sentence, a lawfully authorized sentence under statutes duly enacted, simply on the grounds that is disproportionate to the offense, and that is a constitutional matter, therefore, under the 8th Amendment, it's constitutionally excessive. So this has led to the development of 2 different doctrines at the court under the 8th Amendment, the cruel and unusual punishment clause. One is sort of a case-by-case proportionality, in which someone says, yes, I was convicted of the offense and I'm sentenced, and it's a lawful sentence from the statutes, but in this case, for what I did is constitutionally excessive. And in this realm, the court will ask first, is there some notion that maybe this is a grossly excessive penalty? And if so, and that's a little bit subjective for the judges, and then if so, the court will engage in some sort of comparative analysis. well, let's see how other people within the same jurisdiction are punished for that offense. Let's see how people in neighboring jurisdictions are punished for that offense. This goes back to Weems, the case of the man in the Philippines, convicted and sentenced to 15 years of hard and painful labor, not just hard labor, hard and painful labor, who said, my sentence is excessively punitive, and it was invalidated by the Supreme Court in the early years of the 20th century. Since then, the Supreme Court has decided about half a dozen cases, including one argued by Dean Chemerinsky, in which it has considered case-by-case proportionality challenges. Many have lost, some have won. Solem, in addition to Weems, in which the court said a conviction, it was a life sentence for passing a bad check for the 7th time, is constitutionally excessive. So this is a on the other hand, there are cases upholding punishments as not excessive. There's a well-developed body of 8th Amendment cruel and unusual punishment case law that says you get to ask whether, as a constitutional matter, the punishment exceeds the offense. There's a second and smaller line of cases in which the court does a categorical proportionality analysis. It doesn't ask, did Mike's offense warrant this sentence, but it looks categorically. And these are the cases that until last year were only capital cases, in which the court had said no capital punishment for non-homicide offenses such as rape, no capital punishment for persons with low intellectual functioning, no death penalty for youthful offenders, juvenile offenders, in which not as an individual inquiry into what you did or didn't do, but as a categorical matter, because of the nature of the offense, non-homicide, or the nature of the offender, child, someone with mental incapacitation, the court would again engage then in a comparative analysis and announce a categorical rule. In a number of cases, categorically prohibiting capital punishment, even again, where authorized by statutes, duly enacted, and no procedural objections to the juries and so forth. Last year, in the Graham case, involving a sentence of life without probation for a juvenile offender who committed a non-homicide offense, the Supreme Court invalidated, for the first time, penalty other than capital punishment on a categorical basis, saying that that penalty was too excessive. Life without parole or probation for a non-homicide juvenile offender was constitutionally excessive. 5 votes for that. Chief Justice Roberts concurred in a 6th vote, though he did a case-by-case analysis. He said, I don't want to go categorical, but on a case-by-case analysis. That's the most recent example of at least Chief Justice Roberts applying a case-by-case proportionality analysis to invalidate a otherwise duly lawful punishment. Okay. Second area of greatest development of proportionality analysis is punitive damages. Not under the 8th Amendment, but under the Due Process Clause. Now the immigration folks are starting to prick up their ears a little bit, right? In which the Supreme Court in an early series of cases said, no, punitive damages do not implicate any kind of proportionality analysis under the Due Process Clause. But then they said, well, maybe it does. And in BMW against Gore, and then more recently State Farm, applied again both a kind of case-by-case analysis in BMW against Gore, and then a kind of categorical analysis in State Farm, where they said the relationship of punitive damages to compensatory damages that exceeds 10 to 1 is kind of presumptively excessive. This was another proportionality analysis. There are a few other examples I mentioned in the paper. The takings clause under Supreme Court precedent requires a proportionality analysis of the 5th Amendment. The excessive fines clause of the 8th Amendment, which is civil fines, civil forfeiture cases, requires proportionality. So, in some ways, my suggestion is no more than a very modest observation that the Supreme Court has said the Due Process Clause, at least in punitive damages, requires proportionality, and that where the punishment exceeds the offense, it may be unconstitutional. So, what about immigration cases? Well, I'm going to mostly talk about the Due Process Clause. But first, let me say that a case that probably everyone has read, also from last year, Padilla against Kentucky, the Supreme Court says where deportation is the inevitable consequence of a criminal conviction, deportation is a penalty. That's going to trigger, I think that triggers 8th Amendment scrutiny of removal orders against LPRs who have been convicted of an aggravated felony and on that basis are subject to removal. Because the Eighth Amendment cases ask, is it a punishment, is it a penalty or not? And the Supreme Court has now held that at least in those cases, it's a penalty. So I think every LPR in America who's in removal proceedings for an aggravated felony, even if they're ineligible for relief, could raise a constitutional proportionality claim, arguing that their punishment of removal is excessive in relation to their offense. And that's a constitutional claim that even under Real ID, the courts of appeals need to hear. And they might reject them in many cases, but it has to be heard. There may be categorical claims there, too, that could be made about categories of offenders, maybe barring from capital punishment, youthful offenders convicted of an aggravated felony, person with low mental functioning convicted of aggravated felony. I think every LPR has a constitutional proportionality claim to be made under the strict Eighth Amendment plus Padilla line. Okay, but take even the harder case, a non-LPR, take an undocumented person. They're not going to get the benefit of the Eighth Amendment line of cases under Padilla. But I think that the Due Process Clause, just as in punitive damages, imposes a proportionality requirement on removal if it's a penalty or punishment. Now, some of you are thinking, right, okay, but Crim-Im says the immigration is civil, it's not criminal, it's remedial, it's not punitive. But the case law requires some scrutiny. The small claim I want to make here is that at a minimum, because a removal order today brings with it a reentry bar, 5, 10, 15, 20 years, or permanent bar, depending whether it's your first removal or an aggravated felony or it's your second entry. There's a mandatory reentry bar. That is a consequence of removal. And the Supreme Court in the proportionality cases has said that if any part of a sanction is punitive in nature, if any part of the purpose is punitive, even if it has both remedial and punitive purposes, then it is subject to proportionality review. That's from double jeopardy cases and excessive fine cases. So I think at a minimum, even a non-LPR facing removal has a claim that the reentry bar portion of that order is punitive. That means you can't come back into this country. There's no remedial piece of that. It's not ending a violation. That's only punitive. Then they have a claim, again, to have a court decide the constitutional claim of whether their removal would be disproportionate to the underlying offense. Let me say just a tiny bit more about this. Steve's going to start sliding over and passing me the notes. In 1998, the Supreme Court decided an excessive fines proportionality case called Bajakijian. I'm pronouncing that no better than DJ, I'm sorry. But, and this involved a man who was carrying money out of the country, and he was supposed to declare it at the airport. And he forgot to declare it. It was totally lawful to carry all the money, but he didn't note it in the paperwork. And a huge fine was imposed, basically to forfeit all of the money. Even though it was totally legal, he just forgot to note it. And it went to the Supreme Court, and the court said that was constitutionally excessive, that massive fine for this sort of underlying offense. And they said, here's how we decide whether it's sufficiently punitive to get into the proportionality scrutiny. We look at the history and the purpose of the statute and so forth. Well, if you do that with the reentry bars, and that I've done in the paper here, if we go back to the start of the reentry bars and look at the history, Congress always intended the reentry bars to punish people. Removal ends the offense. The reentry bar punishes you for having committed the offense. So I think as a litigation matter, as a legal strategy matter, I think that there is a claim that everyone facing removal has the opportunity to argue that their removal is constitutionally disproportionate to whatever offense it is within removal proceedings. The LPR case, I think, is easier. The undocumented case is harder, but even there, I think you have the claim. Now, Letty's thinking, who are you going to be repudiating now? Because the analysis is, in part, a comparative one under the proportionality doctrines, under all these different provisions. It's a little bit of a comparative analysis. But I think it's potentially powerful. So I say it's a small idea in part because it's a borrowing, right? It's noticing developments in the Supreme Court doctrine in one area and suggesting it may have application. The Due Process Clause requires fundamental fairness in immigration proceedings. I think that the Due Process Clause applying in punitive damages cases is the straight path in, even in the undocumented cases. And here's an interesting thing, actually. The proportionality scrutiny in the punitive damages cases is much intenser. The verbal formulations of the standards are much more rigorous. The court is much more protective of big corporations that might have to pay punitive damages than it is of criminal persons convicted of criminal offenses. So if we're under the due process clause, this is one of those odd places where there may be a borrowing that results in closer scrutiny. Okay, but beyond the perhaps modest but maybe important observation that I think people can and should be making proportionality claims in individual cases, we're starting to throw it into our briefs, and I encourage others to do the same, is that I actually think it may help with the language. A lot of the talks have been kind of grasping for language to get past the debate that, as Tino explains, feels very stuck. And I think that the language of proportionality is not only a doctrinal development in other areas of law, I think it actually fits. I think it actually fits with how a lot of people think the world should work. And there will be disagreements in application and at the margins about whether this offense is serious enough or not. But the notion that we shouldn't punish excessively, I think, fits with a lot of people's view of the world. It may be pragmatic, but I certainly think it fits with the fairness. And I think that there's a space to talk about the sanction not being excessive in relation to the penalty that may be helpful. And it may be that through some of the case-by-case adjudications that are possible, courts themselves will articulate it. It may be in other arenas this is a helpful language. In the paper, I note a series of what I take to be the most likely objections, and if you want to hear what those are, you have to read the paper, I think, because I'm out of time. But I'll emphasize that I think the strongest objection is probably the continuing offense objection for an undocumented person. So you say, Mike, you're saying that the court would enjoin a removal or vacate a removal order as constitutionally disproportional. For an LPR, okay, maybe they are restored to their LPR status. For someone denied relief, maybe they get cancellation. But what about people who are not eligible for relief and have no status? Aren't you ordering them to be allowed to stay? And I think that's the strongest challenge. I think that there are some things to be said about that. But I think that the possible difficulties as you play it out in the hardest cases does mean that, especially for LPRs or those eligible for relief, the claim could not be there. And I think on a categorical basis, for instance, Dreamers, who we're going to hear more about in the bill later, but have come up, may have the very same kind of claim that in the capital defense context has been the most successful categorical claim for relief. All right, I think I'll close just by saying this is obviously not a panacea. At most, it will smooth out the far extremes. In the criminal context, it's not like courts are routinely setting aside duly imposed criminal sentences, but sometimes they do. I've highlighted the Supreme Court cases, but there are more decisions in the lower courts. I think it creates the possibility to invite courts to set aside removal orders in some of the extreme cases and to engage in a conversation, not only, Juliette has done important work on, I don't know why, for instance, Congress should consider immigration relief that it better reflects proportionality values, but why courts must, as a matter of constitutional requirement, adjudicate these claims. And that may bring courts more into the conversation than they've been on some of these issues. Okay, thanks very much.
Okay, so three very interesting projects. I'm just going to pose a question to each presenter, have them respond, and then open it up to general questions. So, Tino, my question for you is, you spent a lot of time in the paper, a little bit of the presentation talking about agency conflict in the ways in which, for example, DHS can make decisions that sends externalities onto the Justice Department and how that's a problem and that creates constraints. And so it was, you take a very negative or fairly negative view in terms of agency coordination and conflict. My question for you is, are there some circumstances under which agency conflict can be a good thing? You know, there's this literature, national security, environmental law, where the conflict actually can have productive effects and force one agency to have internalize the goals of another agency that they were not otherwise considered. So that's just something like you talk about. Deep, you talk about how border policy has persisted despite the irrationality of it. And for you, you're really seizing upon this notion that, well, it's a psychic comfort that it provides. My question for you as well, is this a case where the public, of not knowing, or the public knowing but not caring? You know, your YouTube clip seems to suggest that people do have an awareness of the ineffectiveness of the border. At the same time, Tino's statistics seem to suggest that border enforcement is one area where Congress has continued to ramp up its effort, and so I was wondering if you had any ideas on that. My question for you is, so in some sense, I see your project as responding to the ratcheting up of immigration laws in terms of targeting the crimes that are the basis for removal and the removals, the narrowing of relief that's available to these classes of immigrants. And I often ask myself, well, what are the conditions under which Congress might then open a safety valve or start rationing down if that in fact is the case? And I'm wondering if you see, you seem fairly, not optimistic, but at least you see the possibility of a claim being made in terms of proportionality. And I'd like you to imagine if a proportionality decision were rendered by the court and it was a good one from an individual perspective, do you think that would then have the effect of Congress to reconsider its immigration policy, or is this just the fight continues?
So I should just start by quickly saying I'm very honored to be in such distinguished company, not just in this panel, but really in the whole conference. I just want to make 3 points, and the overarching theme of my answer is just that this whole question of how you organize agency functions is really complicated, and it's one where many Americans feel, as they do with respect to the consequences of the fence, capable of shooting from the hip and proceed with caution. So the first point is that any effort to organize agency functions to harmonize one set of functions almost inevitably creates disharmony on another dimension. So one way to illustrate that is that a core motivation for reorganizing immigration and border functions the way we have now done so was to unify, for example, Customs and Border Protection's mandate with respect to securing the physical border, and to unify immigration and customs enforcement with respect to interior enforcement of customs and immigration laws. But of course, as you know, by doing that, we've split the immigration function now. So one kind of unity implicates another kind of disunity. The second point is it is absolutely the case that some fragmentation of functions can have a variety of effects, and some of those effects look beneficial from particular perspectives. A key question is, what is your perspective? What are you trying to maximize? So let me contrast, or at least put on the table, food safety and drug enforcement. So on illegal drug enforcement, the creation of first the Bureau of Narcotics and Dangerous Drugs, now Drug Enforcement Administration in the Justice Department, taking agents away from the Treasury, created at first the idea of this newly harmonized drug enforcement bureaucracy. But two things happened. One is that other bureaus grew back their drug enforcement functions after the drug enforcement was harmonized. So you saw the FBI and the Customs Service kind of get back into the business. And the other is that there's a pretty good case to be made that if you think that intense, if not extremely aggressive drug enforcement is a good thing, the dynamics of competition among these agencies has helped bring that about. But then that raises the question, well, what are we really trying to maximize? And then I'll just contrast that with food safety, where I would argue that a somewhat productive tension has existed between the Department of Agriculture and the Food and Drug Administration, in which you see different functions, so one agency dealing with meat, poultry, and eggs, and another dealing with pretty much everything else, but where they borrow methods and tactics from each other in ways that suggest that rather than centralizing, sometimes there is something useful to be gained from splitting functions to some degree. But the last point I want to make finally is just, you could argue that maybe there's some optimal degree of diversity in functions. I do think there's an important point here, which is that if you disaggregate things too much, it really does become hard to implement changes. It does become hard to harmonize these different positions. And I would just put that as one of many factors for why the executive branch has a hard time just moving immigration policy collectively in one direction or another.
So again, let me just thank you guys again for putting me on the panel, but specifically to Mike and Tino. This is fantastic being up here with you guys. To think about your question, Stephen, I guess here are some thoughts, right? I did say that border policy, or muscular fortified border policy, continues despite what appears to be the irrationality of that policy. And that claim, though, it needs to be, it depends on if you're measuring rationality by the claim of what the Secure Fences Act says it's going to do, which is to stop unlawful border crossings, right? But you could think that that's actually not the purpose, in which case it may very well be rational. On the nature of knowing sort of what the underlying forces of migration, the ability to actually stop. I mean, I think this is actually the point, right? That is, it's really, I think, fundamentally a story of the ability to manipulate or exploit information differences, or the way to create information differences as between lawmakers and the public. I think that's one of the stories that's being told here. If we think that the outcome of public policy is in some way information aggregating, right? That is, that as an individual you may have some thought about whether a particular public policy outcome is going to work, and then you see it actually voted on in a deliberative body, and that produces a public policy. You might think that actually that information is better than any individual information you have, right? At least that's one theory of how law might work to create better information. In this case, obviously, lawmakers, despite knowledge of the fact that non-contiguous 700-mile fence is likely not going to stop unlawful border crossings, right? Congressional research report from March 2009 makes the point very clearly that the fence is not working. In fact, it's just causing deaths, and the number of tunnels and ways around the border have increased. But the ability to create that fence and then create the perception that it is in fact going to stop unlawful crossing is, I think, partly the point. The other part about knowing that I think something like a tangible border fence policy does is that it makes plain immigration law. And so if we sort of think more broadly about that point, I think this is underlying the slogan that you often hear, right? What part of illegal don't you understand? Obviously, for most people who work in the area and teach, the answer is quite a lot, really, right? That it's a difficult sort of thing to understand. But if you build a fence, then you don't have to think of it as that complicated, right? And so that any individual can actually make the assessment of unlawfulness. And I think this is partly the intuition upon which part of, for example, SB 1070 is based on, right? If you provide local law enforcement the ability to arrest or to stop people based on some reasonable suspicion that they might be removable, right? Obviously, that's a fairly complex underlying decision that has to be made. But if you think that immigration law is so simple as to just simply think of it as a trespass, then it makes sense. Arizona SB 1070 makes a lot of sense. I think the final point I'd say is that in terms of measuring what the public actually knows, I mean, one interesting thing to look at is are interested public actors. Here, taking a look specifically at the Minimum Civil Defense Corps, right, the group of people at the border, all private actors. And when they build fences, and they do actually build fences at the southern border, they do it on private property, so they'll approach ranchers and say, look, your backyard is up against the international border, very close to it, so can we build a fence? We'll pay for it, we'll build it, you don't have to do anything, and it's going to be a part of our helping out with federal border control strategies. And I think there's two things that might be happening there. One is part of the express strategy of the Minutemen is to embarrass the federal government into action. If you think if that's what their strategy is, that's probably based, or we might argue based on the idea that you want to embarrass the federal government into actually building a fence because you believe the federal government has the power, the omnipotence to actually stop unlawful crossing through the fence. You might just think but you might also think that this is important to do, even if I think as a private individual that I'm actually not going to stop border crossings. It's an important signal, right? I just want to build it, and clearly if you're building it on private property on a ranch and you can't go beyond the property line of the ranch, you got to know, even as a Minuteman Civil Defense Corps member, that fence you're building can't actually stop anybody, right? You can stop people from that private property, but most likely it's going to keep the rancher's cows on one side of the property line, right? So I guess my point here is only that I think that's a complicated question, right? What do people know? But I do think that's the story of the fence, right? It's the ability to manipulate information as between public and private actors.
I take your question to be in part to imagine a world of proportionality claims and then what happens in the interaction between courts and the legislature, for instance. I think, how wonderful it would be if we were in such a world. But I say that in part because, obviously, I'm talking about a constitutional claim here, so it's not easily legislated around, perhaps. But, I mean, what I imagine in the short term and then in the medium term, in the short term is that it's a litigation strategy for those defending removals. It's an opportunity to tell stories and be heard, where right now one of the deepest frustrations is that nothing counts. If you have an aggravated felony, it doesn't matter what else. How you've led your life, the family you've raised, the jobs you've held, the community ties you've developed. Not that we need any of those at all, Letty, but I don't mean to keep picking on Letty, but whatever the criteria become that are positive that you want to share in your life, none of that counts, and this makes that a little bit relevant, and therefore at least the courts hear it, and maybe they reject it, as they do in criminal law cases, nearly all of the time. But I think that there's an educative function there, there's a dignitary function there, and eventually courts will start to find cases, and you see them. In the paper I mentioned, it's a decision about a week ago in the 11th Circuit that kind of bounced around the listservs because the 11th Circuit panel basically had a sort of cri de coeur about how awful this was, that their hands were tied, they could not stop this removal from happening. And that was out of the 11th Circuit. You will see that sometimes. So I imagine what would happen is some courts would begin to identify some cases where they thought removal was excessive in relation to the offense. And then Congress could react in a couple of ways. They could begin to hear those stories because they're coming through these official channels of judicial opinions in a way they weren't hearing them before because it was just advocates shouting them, or however they dismissed them. I think a potential legislative response, and this is partly what Juliet was getting at, was creating intermediate penalties or intermediate relief that doesn't currently exist. If removal is too extreme to be imposed in some cases, but Congress still wants to punish, they might have to begin to develop intermediate punishments. Right now we're stuck. It's an on-off switch. Remove, don't remove. But there aren't intermediate punishments. And I guess I'll sort of end by saying one of the most important things about the proportionality analysis, as opposed to double jeopardy cases, which also get into some of this. Double jeopardy says, can you prosecute a second time for the same underlying offense? You've been criminally prosecuted, now there's a civil forfeiture case coming. It's yes or no. And the Supreme Court's been very reluctant to say you can't bring that second proceeding at all. But when it gets to proportionality and excessiveness, even in those same cases, civil forfeiture is not punishment for double jeopardy purposes, therefore you can bring a civil forfeiture proceeding after a criminal prosecution for the same offense. The court in Bajikajian said, nevertheless, we're going to scrutinize that civil forfeiture for excessiveness. We're not going to take it away completely, we're going to look and see whether you just went too far. And so if ultimately Congress created a more of a sliding scale of penalties or something that allowed some punishment but not the extreme form of removal, I'm not sure that would be a bad thing. Of course, it could go the other way. After St. Cyr said judicial review, as a matter of 2241, habeas statutory jurisdiction, the Real ID codified that rather than repealing 2241. So it's also possible that Congress could end up codifying a decision in a positive way. But, that'll be for next year's symposium.
Well, this is actually a follow-up on Stephen's question to Mike on the proportionality, because he posited it as sort of a choice between congressional action and constitutional rulings. And as I was listening to you, Mike, I was thinking about a number of ways in which you could have a constitutional argument drive things in ways that are not the hard to get explicit constitutional ruling. And so let me just throw out a couple on we think about these. And one is you can understand Padilla really as a case where the proportionality is really what drives the decision. I can imagine how you could turn the proportionality argument into a due process argument about lack of notice. I mean, you sort of see that if you look back to a case like RCA's. I can see this as also like a way that you can argue for a broader scope of judicial review on the ground that this is not a discretionary decision anymore, but rather one of the law. You could argue for different remedies for post-departure cases. I mean, this is just a way of sort of mediating this sort of choice between constitutional rulings and legislative action. And the suggestion, and I don't know, or maybe this is a question if you want to address it, is the European. I think that in other constitutional traditions, like the German constitutional tradition, but also in some of the European human rights cases, I mean, there's much more talk of proportionality. I'm just curious if there's any things that we learn from that with regard to how the idea of proportionality manifests itself in a choice of constitutional, subconstitutional, international law or legislative norms?
Well, that's a fantastic question from Mr. Phantom Norms.
Yeah.
But I mean that quite seriously, right? That yes, you must be right that even if courts may hesitate to rule strictly on proportionality grounds, if one is allowed to articulate that argument because it's a cognizable claim, it could well prompt courts or the legislature to amend other procedural rules to achieve a similar outcome. And maybe that's what Padilla, is, as you said. But this, I think, potentially gives an above-board space to make a bona fide claim, which could get adjudicated in a lot of different ways. I completely agree. I think that's a great point. Also, I note in the paper that proportionality is manifest in European traditions and international law traditions, and I have barely begun to read. I know it's there, and I know that there's a very active discussion of proportionality among criminologists and political philosophers. Whether you're sort of utilitarian and you're worried about excessive punishment just as bad policy, or you're retributist and you're concerned about just deserts and so on. There's a lot of interest in this idea, and I think it's not new, it's ancient, but it's continued for centuries to have meaning in a lot of analytical circumstances. So that partly draws me to it, not as like a clever doctrinal move only, but because actually there's something there, and there's been something there for a long time. And I don't know anything about the German Constitution, but I do know for sure in the European decisional law and in international humanitarian law, lots of places you see this as a quite important concept.
So I see the queue slowly growing, signaling to me. Let's start with Kathleen and then Jennifer, and then go from there.
Thanks so much for the panel. I learned so much. My question is for Mike, and my area is not criminal defense, and I just wanted to ask you whether you thought three strikes appeals was an appropriate analog for proportionality, and whether, my good friend, Mike Romano at Stanford, who runs this three strikes clinic, I'm wondering if there are some arguments with respect to proportionality that can inform your project. And though it's three strikes to state law, or just an example, his success with these appeals represents superseding of the state mandate to implement what prisoners after three strikes.
Well, as a strictly doctrinal matter, it's a terrible analogy because we lost that one, or that case we lost. The Supreme Court said it does not violate proportionality principles to have three strikes law in cover. So in principle, yes, that's exactly right. But that's unfortunately been decided by the court. But I think Mike's experience maybe suggests an additional opportunity, kind of along the lines of Hiroshi's suggesting that if there's a proportionality claim to be made, then maybe a conversation with the prosecutor becomes easier. Right now, often one pleads for mercy with ICE prosecutors, but there's no leverage, right? There's no alternative. But if there's the possibility of having a litigated proportionality claim, even if the prosecutor is pretty confident they're going to win, there becomes that space potentially to have the conversations Mike has with the prosecutor quite a bit, which then results in justice in some cases. And again, people have written about the importance of prosecutorial discretion in immigration, which is certainly important. This might give a space to kind of mandate that, or you have a little bit more leverage to make those conversations happen, not necessarily a particular outcome would be available.
I just had a couple of quick questions for the panel. The first is for Dee, and I found this really interesting. I particularly like the way that you talked about the way this kind of gives life to trespass doctrine, and that's, I think, particularly relevant in light of the kind of trespass cases that you see popping up every now and then in New Hampshire and Arizona in this context. But one of the things that I thought was interesting was you said this defense is kind of linked to law in some way, and there's, you've attached legal consequences to entry without inspection, and fence is kind of a physical manifestation of that legal move. What's interesting to me is that it seems like the border, the physical crossing of the border, the illegal entry, has become less significant as a matter of law since 1996, when we kind of moved from entry to admission, when we've imposed all these bars for unlawful presence. So it becomes kind of being inside and not the actual kind of physical act of crossing that becomes the critical moment for legal analysis. And at the same time, that's when we've ramped up the border enforcement, right? Which struck me as slightly ironic, right? It seems like that would be the moment when you ramp up internal enforcement. You've now kind of made it viable to criminalize the being there, as opposed to the crossing moment. And so I was wondering, it kind of resonated with what Tina was saying, and struck me as, is this just another example of designing a deliberately ineffective scheme, right? It serves a messaging function, but actually its linkage to law is very, very unclear or uncertain. And my question for Mike was about proportionality review, and I'm thinking about, the bad criminal law case like Carmeline, where you get huge sentences for very small quantities of drugs. And a lot of the discussion in the case law is about kind of deference to Congress here. And so I'm wondering what happens when plenary powers doctrine meets the deference to Congress rationale that you see in proportionality review cases. What kinds of outcomes do you expect? I like the idea actually of raising the proportionality review in both the kind of eighth amendment and due process topics, but I wonder if you see possible problems there and how you deal with those.
So I think that's a really interesting and good point about the change of the line to admission rather than entry. Ayelet Shakar wrote an article recently called "The Shifting Border." I forgot what it was called.
Shifting border immigration
Right.
regulations stand for
Yeah. Thank you. Right. In which her, I think what partly her project there is to sort of contest the notion that the nation state is losing its salience, right? And part of what she's arguing is that what's actually happening is by stretching the border 100 miles inland, by changing the idea to admission rather than entry, and to allow extraterritorial sorts of stoppages of people before they come in, that it's actually a very robust conception of nation-state power. And I guess, my thought, though, is that we could read that story in two ways, right? We could say that we could buy that way of characterizing it. But we might also say that this is consistent with sort of the last throes of the importance of the nation state as well, right? That similar to like, I've run out of good ideas, so I've built a wall. Similarly, I need to the border as sort of the line is no longer useful, so I need to change my way of thinking about the border, right? I need to extend it. I think both are interesting, regardless whether you think this is sort of the ascendancy of the nation state or its decline. I think at the end of the day, you have to, one thing that both do is they limit your policy choices afterwards, right? Because if you think a border wall is actually going to work, a physical wall, and it doesn't work, and you think about the times at which border walls have, at least for a short time, work, they usually only do when you're willing to back them up with guns, right? Thinking about the Berlin Wall example, at least for a while. Successful. So yeah, I mean, I think it's a really good point. I have to think about it more. My initial thought, though, is that it's not. I think both of those stories can be told in a way that are consistent with each
other. So objection number 3 in the paper is plenary power doctrine, right? Number 2 is continuing offense. Number 4 is floodgates, also not a problem. Right, exactly. Institutional design, not a problem. So plenary power doctrine, yes. Of course, that is a potential kind of absolute wall to the proportionality argument. But in the proportionality cases, you're generally dealing with state laws, not federal laws, and there's a lot of deference to states since you have, it's Graham against Florida. It was a Florida scheme, and Congress, the Supreme Court said, no, it's excessive. So I don't think the plenary power should end the discussion. I think it's a more forceful objection on the categorical grounds, because that gets a little closer to kind of a facial challenge, to say you can't remove dreamers. That's a little bit more of a facial challenge. The as-applied challenges that would be inherent in a case-by-case proportionality analysis, I'm not sure are so significant. Even if courts were to start saying, no, plenary power, we're going to defer in this case, I still think the fact that you're making the arguments and the courts are hearing them probably serve some purposes. And I take heart from the punitive damages cases where you went through, a period of years where the Supreme Court said this is not a cognizable claim. Eventually coming to, well, maybe there's something, well, okay, maybe we'll set one aside. Okay, here's some standards. It may take some time to develop. But I think that especially in a case-by-case basis where it's more of an as-applied challenge, that doesn't seem to me to fit so badly with the fundamental fairness, immigration, kind of due process analysis.
So unfortunately, we're out of time, but I do encourage all of you with questions to come down and ask them individually.